Hello, everyone. Thank you very much for making time to be with us. I'm Jacob Phelps from Lancaster University, from where we help convene the Conservation-Litigation.org network. And it's a pleasure to have you and our speakers with us here today. It's let's see, 4 a.m. in Floyd, Virginia, 9 a.m. Where Margherita and Joana are. And let's see, 5 p.m. in Tokyo, where Rika is joining us from, and welcome for joining us. We hear, of course, a great deal about climate change, the biodiversity crisis, and often we talk about this as an ecologist, as a scientist, we talk about these issues as intrinsically linked and the feedbacks and so among them, and the idea of their separation, despite obvious different drivers, but so many of these drivers are also shared, and some of the impacts are also shared. So as an ecologist, we talk about these issues as intrinsically linked, and often our solutions as intrinsically integrated. But in law and indeed in policy and in life, that's not always necessarily the case. And sometimes that distinction is strategic and intentional, and sometimes it's perhaps not. And so our speakers today are going to help us think through a little bit about the relationships between climate litigation and broader litigation, including related to biodiversity and the broader environment, and why those distinctions exist, where they're helpful, where they're not, and what the opportunities are for their greater integration. We're going to be starting with three quite short overview talks from our speakers, and then we're going to be opening up the floor for questions and discussion. We'll be keeping it to just about an hour. Our first speaker is someone that you likely already know, if from nothing else than from this series of incredibly helpful reports and the database of climate change laws of the world. Joana Setzer is one of the leading scholars on climate litigation and has been incredibly helpful to our network as we've been trying to learn from the successes and challenges of climate litigation and its application to broader environmental liability litigations, which is what our group is particularly connected to. We'll then be hearing from Margherita Cornaglia, who is one of the leading barristers in the UK and indeed globally, who's been working on climate and environmental litigation and tackling really some of the most contentious issues, I think, of our day. And finally, we'll be hearing from a longtime friend and colleague, Rika Fajrini, who has been working particularly with environmental liability laws and litigation in Indonesia and Southeast Asia, and as part of that, doing a great deal of work with judges, trying to help them understand the relationships and the challenges among all of the different elements that we're going to be discussing today. So without further ado, please let me pass it over to Joana Setzer at the London School of Economics.
Yes. Okay, now it worked. First time didn't. You can hear me now, hopefully. Great. Okay, so well, thank you so much, Jacob, for this invitation. And I didn't realize it was 4 a.m. for you. So yes, I'm sorry for that bad timing. But good morning or good evening if you haven't slept yet, and good afternoon around the world. So as Jacob said, I want to give more of an overview of what we'll be talking about, and then hopefully we'll be able to go into more details as the presentations go. And what I want to talk about is this intersection between two fields of legal activism, legal accountability, that not obviously have come together, whereas, as Jacob said, if you think in terms of ecological, environmental terms, they are obviously together. So climate litigation and biodiversity litigation are both areas that are critical in addressing the environmental crisis. And while they're still often thought or treated also separately, they are very intertwined. And I want to talk about how they are intertwined. So this argument that climate litigation is also about biodiversity, I've been making already for a few years. I think it's really important that we continue to make. You'll see it's there in my in our global trend reports. And also, I'm now working on a paper that specifically maps this type of litigation. So it's a paper with a colleague, Annalisa Savaresi and Alice Bisio. And I'm going to mention also some of the findings of this paper, because interestingly, there hasn't been yet an attempt to map the intersection between these two fields. So in our analysis in that paper, we're looking at around 80, 90 cases of forest and climate litigation where climate is central to the case. So a lot of what I'm going to say is based on that working paper, which hopefully it won't take too long to be published. So in this presentation, I want to start talking a bit about the shared drivers, but I won't go too much because this is the ecology part, which we said already, it's obvious, and then go into the legal part of who is bringing the cases and what types of cases we see where this interaction is taking place. So in terms of the shared drivers, as Jacob said, they are intrinsically linked, but not necessarily in law. And this is the exercise that we sometimes try to do with litigation, is to show that in law, these two are connected. Whereas, while one constitution says the environment is protected, the other one says climate is protected, you need to kind of link even the two, or sometimes often climate is not protected in the constitution. So let me give you a few examples here. So climate and biodiversity have common drivers, and the legal response sometimes overlap. And human activities like deforestation or industrial agriculture and the exploitation of natural resources not only contribute to climate change, so you have the emission of greenhouse gases, but also destroy ecosystems. So this is the basis. This is the shared driver that I was talking about. So if you think about deforestation in the Amazon, Indonesia, the Congo Basin, all of these not only contribute significantly to greenhouse gas emissions, but also they lead to the extinction of species, animal plants, and this is the problem that we're facing. So in principle, if you litigate against deforestation, you would be serving both climate and biodiversity. So I think it's important to say that biodiversity litigation has been around for decades. When I was a young lawyer many, many years ago, this is what I did most: biodiversity, deforestation litigation. What we are talking about now is how we bring together these two fields that ended up separating, climate and biodiversity. But let's not forget that biodiversity has always been around. Climate litigation is newer, but climate litigation has some pretty interesting, creative strategies and has achieved quite big decisions. And this is what we're trying to understand, how one can help the other. So it's about this synergy between two, one that existed and one that is newer and has achieved quite a lot. So in climate litigation, we tend to, and in litigation in general, we try to understand who's bringing the case against who, right? And usually the way we see is that litigation is often brought against public actors. So the majority of climate cases, and also if you look at biodiversity and climate, they are filed against states and public authorities. And this makes sense because it reflects the role that these have in land use regulation, in forest management, in regulating greenhouse gases. So it makes sense that you would see a majority of cases against these actors. In the paper I told you with the 90 cases, around 65% were filed against states and public authorities. So good, this makes sense. Now, this doesn't mean corporations are not important. Corporations are also key defendants in both climate and biodiversity litigation, because ultimately the extractive practices that ultimately result in destruction of ecosystems and emissions, these are often done by corporations. So in climate litigation, we see fossil fuels as the main target of climate litigation. And it makes sense. They contribute to a significant amount of emissions. But sorry, when we're thinking about biodiversity and climate, then we have other types of industries that are driving biodiversity loss, such as mining or logging or industrial agriculture. And these are then the defendants in such cases that combine climate and biodiversity usually. Very well. Now, I want to, in this last part of my short talk, cover some of the legal frameworks and synergies between these areas. So this is based on the paper, and what we do is, while climate litigation has often focused on reducing greenhouse gas emissions and enforcing national commitments, a lot based on the Paris Agreement or domestic climate law. When we think about biodiversity, we will have slightly different sources. So we will think about internationally the Convention on Biological Diversity, the CBD, and also domestic environmental law. So different bodies of law, and again, this is where we have to understand how they come together. So they're not mutually exclusive, and both legislation and litigation to protect ecosystems like wetlands or forests or mangroves can simultaneously prevent carbon emissions and enhance climate resilience. So let's see how this is happening. So we divide the body of cases into a few. You know, we love typology, so we can't resist not doing that. So the first are cases that are both about climate and biodiversity. And we have a number of cases that are relying on generic environmental forest laws and also on climate. So here we have lots of cases in Indonesia, for instance, some against corporations for causing peatland fires. And we also have cases such as the bush fire survivors in Australia. So there's a case against New South Wales where it's challenging the inadequate response to protect this ecosystem and stop bushfires. These cases, they will engage with domestic legislation or even with the Paris Agreement and also with forest legislation. Now, what's interesting is that we have seen in both fields now an emergence of human rights arguments as being more present in these cases. So we see that in climate cases and we see that in biodiversity and climate cases. I think the first big example was the one in Colombia, Future Generations against the Ministry of Environment. But again, we see the case in Indonesia. There's an Indonesia Youth versus Indonesia in 2022, where what is argued is that government's insufficient climate action violates applicants' human rights, and these are recognized by constitutions in Colombia, in Indonesia, in other countries. And there is a clear effort in these cases to bring the climate angle and the biodiversity angle together. So they're protected by the constitution. You have the human rights coming in, and it kind of ties it all together. But we also see some cases where it's more about the human rights and biodiversity and climate playing a less important role. And in Brazil, there are quite a few of these. So we see also human rights becoming stronger with the idea of due diligence. So a few examples here. I'm picking examples from around the world, and I think there's a really interesting one that has this transnational aspect to a case against corporations. So this is a case not only not against a corporation that is actually causing deforestation, but financing deforestation. So it's a case brought by an NGO in Brazil against BNP Paribas in France, based on that idea that BNP Paribas is financing deforestation. So you can see how there is also the possibility of, with this human rights due diligence angle, bringing not only the one that is directly causing, so burning, chopping forest, but also financing that in some way. And then cases that have the stronger human rights and climate angle, with biodiversity being less important, but that ultimately are also about biodiversity. So here, I think we have also cases in Brazil where the issue has been the targets that the Brazilian government has committed to, and these are said to be insufficient. And at some point in the petition, in the filings, there's also allegations that this will increase deforestation and that there are violations to the right and healthy environment and other fundamental rights. But similarly, also a Finnish case where an NGO file a case against the government, the case is more about climate and human rights and a bit less about biodiversity. So what I'm presenting here is a whole spectrum of having climate and biodiversity, climate and biodiversity and human rights, biodiversity and human rights. So you can see there are like many versions, and we see them differently in countries, both in cases against governments and against corporations. So to finish, I think there's a smaller group of cases that really tries to bring all of that together: climate, biodiversity, and human rights. And these are quite creative, interesting cases. And the example that I would bring here is, again, a Brazilian case, which I think it helps the fact that I was a Brazilian lawyer, but I follow these cases more closely. But also, Brazil is the country with the largest number so far of cases of climate and biodiversity. So the case is the Amazonian Studies versus Brazil, that requests the court to compel the federal government to comply with the Climate Change National Policy Act, but also to declare the recognition of a fundamental right to a stable climate, and all of this to protect the Amazon forest. So this is one of those cases that we see this kind of quite all these angles being very present, both in terms of the legislation that is used in the case and the arguments and the science. So the case also has like extended scientific papers by both international but also by Brazilian scientists, showing that protecting the forest avoids X amount of emissions, and that this is a human right. So it has all those three angles very strongly presented, defended with law and with science. So I think this kind of gives you hopefully an overview of how these two areas of law are intersecting. As I said, looking forward, I think this intersection between climate and biodiversity law is likely to grow. And the legal community is trying to draw more these connections. And I think this webinar is part of that, of understanding how these connections can be drawn and how they will benefit the litigation and, of course, the most important, the protection of biodiversity and climate. So to conclude, while climate litigation and biodiversity might have run in parallel and might continue to an extent, this conversion is increasingly, and I would argue it's beneficial to both. And in both, it's holding governments and corporations accountable for actions that degrade the environment and recognize this interconnectedness between ecological systems and human well-being. So I'm looking forward to the other presentations and also for the Q&As. Thank you very much.
Thank you very much, Joana, and including for taking the big task of being asked to set the scene. It's interesting and helpful to think about these as really as a continuum and as various permutations that help us get towards greater integration. Please let me pass on to Margherita.
Thank you. I was just trying to unmute myself. Thank you so much for having me, and thank you to Joana for that great introductory presentation, which I'll follow quite seamlessly, because what I'm hoping to do is to give you a specific example of an ongoing climate case, strategic climate case, where the question of the decoupling of climate and biodiversity comes up to some extent, and which I think shows the risk that might materialize if we decouple climate and biodiversity in some of these proceedings. What I'll focus on are the proceedings which are currently pending before the International Court of Justice for an advisory opinion on climate change. Now, the International Court of Justice, or the ICJ, is asked by Resolution 77-276 of the General Assembly to provide an advisory opinion which answers two questions. The first question is, what are the obligations of states under international law to ensure the protection of the climate system and other parts of the environment from anthropogenic emissions of greenhouse gases for states and for present and future generations? And the second question is, what are the legal consequences under these obligations for states where they, by their act or omissions, have caused significant harm to the climate system or other parts of the environment. Now, one of the key questions that has come up in those proceedings and on which states disagree is the question of lex specialis. Now, lex specialis can translate to sort of a special regime of law. And what it is it's a legal principle that is used to decide what law applies when there are multiple laws that address the same subject matter. Now, when there is a more general law and a more specific law, and both those laws address the same issue, generally the more specific law will take precedence over the general one. So in short, it's a more targeted rule that dominates in a case of conflict of subject matters. One of the debates before the ICJ today in these advisory proceedings is whether the UN climate change regime, which is largely made up of the UNFCCC and the Paris Agreement, is a form of lex specialis, such that it governs in its entirety all the obligations that states might have to protect the climate system and other parts of the environment. The reason why some states argue this is that obviously means that their obligations are much narrower and weaker than they would be if their obligations weren't entirely defined by the UN climate regime. Now, I've had the privilege of working instructed by Omnia Strategy with Albania, who's one of the states who presented submissions before the courts, and they resist this argument. They say, and they agree with many other states, often small island developing states or some of the global south states that really drove the process that led to this request for an advisor opinion. They argue that the climate regime under the UNFCCC and the Paris Agreement does not entirely define what obligations states have in this respect. And similarly, it does not entirely define what the legal consequences might be for states if they breach their obligations at international law. So what they say is states actually have obligations that are much wider. They are defined by a whole number of international laws, treaties, and norms of customary international law. So these include, for instance, UNCLOS, which is the UN Convention on the Law of the Seas, or the International Human Rights Regime, which has a whole host of obligations, which they say apply equally to the climate space, to the climate space. And multiple other laws and norms. The reason why they say so is that ultimately the UN climate change regime does not comprehensively regulate the obligations that states have to protect the climate system. Those obligations are much wider. The UN climate regime is quite narrow. It doesn't address everything. It doesn't provide for any legal consequences, really, if states don't comply with their obligations, say, under the Paris Agreement. Another argument that they bring forward is that the UN climate change itself refers to other principles and norms of international law. So the UNFCCC in its preamble, for instance, refers to the Stockholm Declaration. The Paris Agreement refers to principles of international law, like the principle of equity and common but differentiated responsibility that preceded the Paris Agreement. And so the argument there is that if these specific treaties refer to other laws and norms of international law, it means that they actually rely on those norms and law. And so those other norms and law must be part of the international legal system that governs the obligations of states in this space. And also the states like Albania rely on the International Tribunal of the Law of the Sea, who just provided an advisory opinion on climate change and refused to accept the argument of lex specialis. They say laws are much wider. So why is this all relevant to the question of biodiversity? Now, you can find online another statement which was submitted by WWF, it's not a state party to the ICJ proceedings, but it has the ability of providing its opinion, and its statement is then kept in the Peace Palace Library at the International Court of Justice. But the reason why that statement is interesting is that what WWF says is that you can't interpret the climate system as excluding obligations that protect biodiversity and ecosystem. And it gives two reasons for that. The first reason is that what WWF says is that the climate system includes biodiversity and ecosystems. We need to interpret climate system broadly because ultimately there are so many different aspects of nature, biodiversity, and ecosystems that require protection and that are influential when it comes to addressing climate change. And then that leads me to the second reason which they give, which is that the protection of the climate system, even if we adopt a narrow interpretation of what climate system means, requires the protection of biodiversity. And the first reason for that is that, as Joanna was saying, there are many different ecosystems that are carbon sinks and reservoirs. So they play a very important role in sequestering carbon dioxide from the atmosphere. And so in removing excess CO2 and mitigating anthropogenic climate change. So protecting those ecosystems and those resources is fundamental to protecting the climate system in and of itself. So why this example? I think this is a good example that shows us what the risks might be if climate and biodiversity are decoupled. If the ICJ finds that the obligations of states pertaining to the climate system are limited to the protection of climate system interpreted narrowly, that means that state obligations to protect biodiversity will be much weaker. However, if the ICJ agrees with states like Albania, but also with WWF's position that the protection of the climate system requires the protection of biodiversity and includes the protection of biodiversity, what that means is that the understanding of state obligations in this space will be much wider and stronger. And it will obviously cascade through indirect impacts. It will have an impact on the regulation of corporate actors because there will be an understanding that state obligations to protect the climate system also involve obligations to protect biodiversity. So we might have, for instance, concepts like the concept of double materiality, which requires companies not only to assess what risks climate change poses to their own operations, but also to assess what impacts they are having on climate, on nature, on water resources, so on and so forth. You can see that concept best expressed in the European CSRD currently, but you might see these concepts becoming much more widespread and popular if we have this strong finding by the ICJ. So I hope this was one small example of potential risks of decoupling these two concepts. And I'll pass back to Jacob and look forward to listening to Rika. Thank you very much.
Thank you very much for that, and indeed for helping represent, I think, all of us in this case. It'll be really exciting and important to see how this develops further. And yes, let's just pass straight on to Rika. Are you there, Rika?
Yeah.
Great. Thank you. Over to you.
Okay. Thank you so much for the opportunity. At this opportunity, I would like to share my experience with Southeast Asia cases and judges, where there are understandably more biodiversity cases compared to climate change. To set the context of Southeast Asia, in a rich biodiversity region like Southeast Asia, biodiversity and climate change is, of course, an interlinked subject. We host 3 of the world's 70 mega diverse countries like Indonesia, Malaysia, and Philippines. We also have several biodiversity hotspots like the Indo-Burma, Greater Mekong countries, the Coral Triangle, and the heart of Borneo. So, of course, talking about climate change, we will inevitably talk about biodiversity in Southeast Asia. Climate change threatens the sustainability of this biodiversity, and the loss of biodiversity accelerate the climate change impact to the Southeast Asia region. And in addition, the biodiversity play an important role in mitigation and adaptation in Southeast Asia countries, as well as its climate commitment. For example, in Indonesia, the forestry and other land use sector is one of the big emitters. So Indonesia relies so much on achieving volume net sink by 2030 in their climate commitment. So protecting and rehabilitating biodiversity also means fulfilling the climate commitment for these countries. looking at this context, of course, then when we talk about climate litigation, biodiversity is almost always become part of it. So to share our experience, since 2021, we have conducted 3 Southeast Asian judges workshop on climate change. And then one interesting thing to note is when we first conducted the workshop, we asked the judges to bring climate change cases in their jurisdiction. And many of them say, oh, we don't have any climate change cases. But then we explain cases that is motivated by climate change, or cases with no climate change framing, but have the implication to mitigation and adaptation of climate change, could also be classified as the climate change cases that we will discuss in the workshop. And then the judges then bringing a cases, and majority of the cases are biodiversity related cases, especially about deforestation and illegal logging. So this is show then when we start talking first about the biodiversity impact in the local area, they can clearly saw it, and then we draw connection to climate change, then they can see the causation clearly. So biodiversity give a case a more local context, which is more easily understandable by the judges. And then climate change bring a global importance to a local context. So the judges learn that their decision could have a broader impact beyond the courtroom. And several well-known climate cases from Southeast Asia usually come from Indonesia, Philippines, and Thailand. When we scrutinize these cases, majority of these climate change cases are biodiversity related. For example, one case in Thailand in 2022, resident of Omkhoi versus EIA committee. It's about the indigenous Karen community, which challenged the approval of EIA for a coal mining project. It's interesting because Joana earlier mentioned about the divergence between human rights, biodiversity, and climate change. In this case, the lawsuit cited the coal mining project would increase emission that contribute to global climate crisis. But more importantly, it also emphasized the impact to deforestation, food security, and livelihood of the indigenous people, which also related to the human rights issue. And the second case is in the Philippines, also filed by indigenous community, Palalawan Indigenous Cultural Communities versus DNR. It's also challenging a nickel mining project that involve 80% of the mining area are in protected forests for the indigenous community. The case main concern is biodiversity, but the implication of protecting these forests, it can contribute to climate mitigation as well. In this case, the Supreme Court of Philippines issued a writ of kalikasan, a remedy that reserved for extraordinarily environmental cases. So we can see how the Supreme Court view the significance of these cases. The last cases come from Indonesia, as also Joana has mentioned. Indonesia recorded the highest number of climate change litigation in Southeast Asia. It's even one of the top 10 countries with the highest number of climate change litigation outside the US and EU. Majority of these cases are cases when Ministry of Environment sue palm oil plantation or logging company, so related to forest fire, land use, or illegal logging. Climate change doesn't explicitly mention in these cases, but it argues on the loss of biodiversity and its habitat, which then result in carbon release and the loss of carbon sink that need to be compensated by the perpetrator. And looking on these Indonesia cases, I would like to share a unique lesson learned. I'm not sure whether it's unique, but it's interesting because in the discourse of climate change litigation that seeks remedy for loss and damage suffered by the victims due to private entity activities and their historical emission, many of these cases often fails, mostly because of the causation question. But then these cases in Indonesia that filed by Ministry of Environment, they have slightly different approach when they demand compensation from the private sector. First, because they, of course, focus on the current emission, not the historical emission. But then also the way the Ministry of Environment argued that the carbon released from the fire and loss of carbon sink itself is a damage that need to be restored. The MOE then asks for ecological loss compensation and restoration costs for this damage. And one of the restoration item is restoring habitat and its biodiversity component. So in these climate change litigation cases, the main remedy that is being asked is restoration of habitat and its local biodiversity. So in this case, it's easy for the court to see that the remedies have a local causation, but then when you restore the biodiversity in the local context, it also contributes to the global impact of the carbon release itself. Of course, there is a question about execution on the ground for this remedy, whether the restoration of biodiversity is actually being conducted. But then this approach kind of give an insight that local remedies, like restoring biodiversity, is part of remedies in climate change litigation as well. And to sum up to end the presentation, those are the cases when we see that climate and biodiversity are seemingly in line in a case, but then we also found cases where climate interest seems to go against biodiversity protection interests. And this is the case that usually involve species protection instead of habitat protection. For example, in Indonesia, we have Tapanuli orangutan case. It's the case of a hydropower plant that is planned to be built in the newly discovered protected species of Tapanuli orangutan in North Sumatra. And then the hydropower plant project is feared to will have impact on the habitat of the orangutan. And also in India, I think we also have, I just read an interesting case, similar case in India that involved the Great Indian Bastard Bird protection versus solar and wind power plant. So it's interesting to see how energy transition involving renewable energy the interest will be balanced with the biodiversity protection. And I think this question also come up in our previous Right of Nature webinar. What should we do? What should judge do when two equally important environmental interests simply go against each other? So that's its food for thought to end my short presentation today. Thank you.
Thank you very much for those insights, Rika. And thank you to everyone who's been putting questions into the chat. Please continue to put those in. Before we turn to those, I would just like to briefly invite Joana or Margherita if there's any points based on the rest of the conversation that they'd like to interject with. But if not, no problem. We can jump into the questions.
I think we can jump into the questions. One of the questions actually speaks to the point that Rika just made, that I think it's important on the kind of when the two interests clash. But let's go.
Please go right ahead with that point then, Joana.
Okay. Well, so maybe just flashing a bit that point. I'm glad that Rika brought it. It is really something that we have to think about in terms of this. We've been calling green versus green, right? When you have, and this is very much the story of just transitions too, when you have human rights of traditional indigenous communities that are being affected by climate policies, or in this case, biodiversity, a bird, a species, many species being affected by the construction of wind or solar, or the extraction of critical minerals for batteries. So you have the situation where it's the litigation will be not challenging climate policy itself, but bringing issues around the protection of species or communities that otherwise might be being overlooked in the litigation, so or in the policy. So I think it's a really important concern, and one that requires from policymakers, for instance, broader participation if we're thinking about the communities, or broader consideration about the species that are being affected when you are approving a development or passing policies that are trying to improve the climate crisis. So the issue of how to balance these two when they are they might be conflicting is one that is not only important, but also I think when it goes wrong, it will end in litigation, which is again not what we want to see. That you have a fight between protecting a bird species and protecting climate in going all the way to courts. But I think that it is something that is likely to increase as we have different laws and policies that potentially clash and leave species or vulnerable communities out. So bringing them in and making these considerations in the process becomes ever more important.
Thanks very much. There are a couple of questions about regional trends and differences, and also in relation to common, but as part of that, what sorts of trends do we see in terms of this integration between biodiversity and climate, notably between Global South and Global North? And also then within that, also the idea of common but differentiated responsibilities, which is a concept, of course, that we traditionally associate with climate change, but not with biodiversity. And I'm curious if any of you would like to tackle that large question. How do we interpret this across different contexts and histories of resource extraction? Joanna, can I ask you to tackle that one as well, or Naila, if you can please unmute.
Classic. Let's go. So, well, I can start, and I'm sure Margherita and Rika can add much to this discussion. So the interesting question about the common but differentiated responsibilities principle, it's a good one because it's true. It's very much part and explicit to the UN Framework Convention on Climate Change and the Paris Agreement, and it's not directly referenced in the Convention on Biodiversity, biological diversity. So I think the way I would see is, okay, so in the climate context, this is articulated and it has evolved in the Paris Agreement. So all states have shared obligations, but the responsibilities are differentiated based on historical contributions and the respective capabilities, right? So this is what it stands for. Now, if we take that to biodiversity and biodiversity litigation, it's an indirect application. Margit might have more thinking around that, but I think it could still influence biodiversity related legal arguments because first there's this idea of the transboundary angle, right, where environmental harm crosses borders, and so plaintiffs in biodiversity litigation could say that countries that have historical biodiversity loss or industrial activity, so the developed countries, have greater responsibility for global biodiversity conservation. I don't know if that has happened, but I could see that you could try to follow that logic of the CBDR and get developed countries to have more responsibility in the financing and technology transfer and restoration efforts. Yeah, would be interesting. Also, if you think about global supply chains, where you have corporations operating in biodiversity-rich areas that have, global supply chains tied to countries that with different economic development. So in this case, I can see biodiversity litigation could argue that companies based in developed countries have more responsibility for the biodiversity harms caused by their operations in developing countries. So maybe that Casino case, there's a really interesting case brought by a group of NGOs in France, and it deals with deforestation in the Amazon, all the way to the beef that is sold in French supermarkets. Maybe I don't think that's explicitly present, but you could see that type of idea in these global supply chains. So I can kind of stop here, but maybe others can add.
I might just add a very brief point on the principle of common but differentiated responsibility. I think sort of obviously, as Joanna said, you're right, that's very much sort of enshrined in the Paris Agreement. But what I was referring to earlier in terms of general norms at the international level that exist and apply, one well-known principle is the principle of good faith in international cooperation, for instance. And that's provided for in general sources of international law, like the ILC's draft articles on the prevention of transboundary harm. And so I think we do see the principle of good faith at least applying in the context of wider obligations to protect biodiversity. I think in the sense that it is a general principle of international law. So that was just a small addition, but otherwise I think Joanna's responded to this question.
Great, thank you. There is a question, that I think would be, I'd appreciate your insights on, Margherita, which is, you're working on this ICJ case. We also have this, Convention on Biological Diversity, COP16 coming up next week.
Yeah.
How do you see these cross-fertilizing one another? Very different types of fora, but high profile and some similar debates perhaps being hashed out.
Yeah, absolutely. I mean, it's a good question, and it's difficult to predict what judges will be thinking. But obviously, I think Joanna can also speak to this. The ICJ, the proceedings before the ICJ were filed strategically at a particular time when there's a whole series of other proceedings in other courts that are also ongoing. So I think someone in the chat box mentioned ITLOS, and they've just given their advisory opinion. We have a request for an advisory opinion, which is also pending before the Inter-American Court of Human Rights. The European Court of Human Rights has just this April handed down judgments in two other climate cases. And so I think obviously all of these proceedings do cross-fertilize each other in some way. Again, for instance, states are now in the ICJ process or have just filed their second round of submissions, and the hearing is at the beginning of December. And in those second round submissions, quite a few states do rely on what ITLOS has said. It's possible that something like that might happen for oral submission rounds as well, once COP16 has taken place. But obviously, it is to some extent a matter of speculation to try to figure out how much judges might be influenced by these ongoing negotiations.
But I think that's really interesting because it reminds us kind of the polycentricity of this system, and there's multiple things happening at different scales at the same time, and they're, including by design, you said strategically not independent, they're not standalone. There's a dialogue.
Absolutely.
And as part of that, actually, I'm curious about your relationship. Obviously, you've mentioned and you're working on these international cases, these international benches and contexts where these advisory opinions are being sought. And I'm curious about working at that scale versus domestic jurisdictions.
Can you just clarify? Do you mean cases that are filed before international courts or that have international dimensions?
Sorry, that's right. Filed at international courts. That's right.
Yes, I mean, so the other involvements I've had were with the Inter-American Court of Human Rights and the European Court of Human Rights. And those are all obviously slightly different because they are cases that rely on regional human rights regimes. So the European Court of Human Rights cases rely on the European Convention on Human Rights. And we've had sort of a very interesting judgment in the Verein Klima Signorinen, which is the senior Swiss ladies case, where the European Court of Human Rights it essentially came up with a novel test when it comes to climate cases that engage Article 8 of the European Convention on Human Rights. But I think going back to the topic of biodiversity, I think one really interesting point to make in terms of the difference between these different human rights regimes is that if one looks at the Inter-American Court, does have established jurisprudence on climate change, and they embrace the right to healthy environment in a way that doesn't really happen in the same way in European jurisdictions. And I think perhaps perhaps because of jurisdictions in Latin America that do recognize that there's a very strong link between human rights and the protection of nature, that in the Inter-American Court, there's this the court embraces a less anthropocentric understanding of human rights. So an understanding that human rights are not sort of purely about the human person, but they are very much defined by this intimate relationship between the human person and the ecosystems and the environments and the species around us. And so biodiversity is, I think, very much front and center in many of these inter-American cases, perhaps more than it is in Europe. It might change in Europe as well. The law might develop, but I think we're not there yet. I don't know if Joanna, you agree with that? I might be wrong, but
it's interesting to think though about those cultural differences in law and in verdicts and what those reflect. Margherita, one of the things that you said, it's impossible to predict, right, how things are going to play out, and it's a speculative game to think about how judges are going to understand and interpret. One of the things that I've appreciated from Rika's work is how much time and insight she's always had with directly with judges through judicial education, and we've learned a huge amount from that. And one of the questions relates to this, highlighting how judges are often quite conservative in matters related to policy here, especially when it relates to the development of what may be incompatibilities with international regimes, Paris Agreement, CBD, domestic legislation. And the question is, how can judges be encouraged to push back against policies approved by governments, but which violate critical international legal principles, human rights frameworks, and agreements? Rika, what sorts of examples are you seeing, and how are you seeing the judges respond to these pretty common challenges?
Right. So this is interesting because this kind of a question also arises in one of our judges workshop in Southeast Asia. And because judges are cautious, they don't want to overstep. They don't want to take what is meant to be an executive duty. And but then from the discussion, it come up that one thing, the judges still need a legal hook of this international principle. So if they have a legal hook in the domestic law, so they can do their duty by saying that the government is in violation of this national law. So they are hoping that they can still build a legal base when the international principle is translated into their national law, which of course will be an obstacle in some country which does not have that kind of legal base. But then we also saw judges that is willing to look at the improvement of the international principle. In Indonesia itself, there is a general provision on the environmental law that judges can look at the international development of environmental law and its principle. And in one of the training for judges, we have this topic called judicial activism, where the Supreme Court of Indonesia actually give guideline how the judge could be creative in finding that legal base. But then again, you cannot expect the judge to step over the boundary. So they will first try to find a legal base in the national context of this legal principle. And sharing the experience, I think it's important among judges. So it's also encourage them to see what's happening in the neighboring countries. It also influence how they could use that knowledge in their local context, that these other countries have already do something like this, and then it's worth trying to deal with a dead-end problem in the local jurisdiction. That's why we encourage regional dialogue among judges to share this kind of lesson learned as well.
That's helpful, and also, again, interesting to think about how dynamic the system, right? And it's not just about cases in a single jurisdiction, or it's not just about domestic legislation versus international. There's a continual dialogue. that I guess you're hearing the judges also engage with in varying ways. As part of that, Joanna was telling us earlier about this continuum and relying on different areas of law, which are not necessarily incompatible, right, between climate and biodiversity. There's a question here, though, about what role conservation-related legislation, conservation law, I guess things like protected species legislation, so on, might play in cases within this nexus between climate change and biodiversity. The person asking the question highlights this because conservation law is often focused on protected species, protected areas, strong bias towards, charismatic fauna, charismatic places, but doesn't necessarily address, more diverse, diffuse, indirect causes of biodiversity loss, including things like pollution and indeed climate change itself. So I'm curious, Joanna, where you see or where you are seeing conservation law play into these. Is it conservation law that is applying to broader things, or is it climate change law that is bringing in biodiversity within?
It's a very good question. And hello, Rebecca. Good to see you. So, look, again, I think my first point is that biodiversity litigation in law exists for a long time, and it always struggled with this issue of protecting the most charismatic and protecting biodiversity in general. But that's a long area that has existed for a long time. Now, I think the way I like to understand this is what opportunities there are for in making this nexus stronger to actually maybe even address some of these issues. So if you think about the kind of the protection of ecosystems as carbon sinks, right? I think that's a helpful one, because you would have conservation law providing tools for protecting critical ecosystems, so forests, wetlands, marine areas. And I think this is where I would be interested to maybe discuss also what might be the impact of the ITLOS advisory opinion, because it will also protect biodiversity in marine areas. And these also serve as carbon sinks. So what I can imagine is that you have, if you protect areas with kind of the existing regulation that has done this for a long time, that would be contributing for both, and maybe hopefully also kind of going beyond that protection of individual charismatic species. Now, if you think about the other way around, I think kind of the specific protection of species and habitats. And you have one species that is threatened, one habitat that is threatened, and a law that is specific about that. We see that in the US quite a lot, right? You have the Endangered Species Act, also air pollution regulation being used in climate and biodiversity litigation. So the US, I think, is one that we are seeing more of this kind of use of other types of regulation because they don't have such strong climate regulation. So endangered species, these are all being quite the only US cases we have will use those. And the same for limiting industrial activities, right? You have loads of legislation around the world on EIA requirements. So if you want to build a new industry, a plant, you have to do an EIA and understand the impacts of that specific development on biodiversity. Now, what we're seeing is that we have cases that are asking for not only consider the impacts on biodiversity and species, but also on climate. So the Finch case in the UK, which is a recent case that was decided by the UK courts, go beyond and says not only your immediate emissions, but your Scope 3 emissions. So I'm saying all of this as examples of how these two areas can help each other. So I think the existing EIA legislation is helping and could help in many countries to have a consideration of climate impacts at the same time as the idea of carbon sinks could help biodiversity. So I'm looking for synergies, but of course aware that there are places, as I mentioned, that the synergy goes in the other way around. So you kind of end up with opposing situations, but started with the positive examples.
Thanks. I'd like to squeeze in one last question. I'm conscious of the time. Margherita, there's a question in the chat about the extent to which the convergence between climate and biodiversity litigation might drive further litigation against directors and officers of corporations globally. And I'm curious whether, because I know that some of this is a debate that's active currently in the UK, and I'm curious if you might have any insights about this, and indeed whether you think, is the UK where we're going to see these types of trends, or where should we be looking?
That's a good question. I wanted to add one thing to Joanna's previous one, and then I'll get to this. One interesting thing about the Convention on Biological Diversity is that it provides specifically for strategic environmental impact assessments, which I think really helps with what Joanna was talking earlier about having this holistic assessment of impacts on sort of environment, society, etc. But going to the director's liability, so as some of you might know, there was a case earlier this year in the UK where Client Earth tried to sue the board of directors of Shell on the basis that they had been in breach of their fiduciary obligations by failing to sort of essentially transition away from fossil fuels, if we can put it in a nutshell. Now, that case didn't go that far, but there's a very interesting opinion which Robert Carnwath, who's a former judge of the Supreme Court and also associated to the LSE, one of Joanna's colleagues, wrote about this area of law. And his view is that that case should have at least been allowed permission, well, should have been granted permission for appeal so that the Court of Appeal could consider that question. So I think there was a bit of a moment earlier this year where the sort of climate litigation community thought that the UK courts had dealt a pretty fatal blow to litigation based on fiduciary to some of these regulatory developments that we're seeing. So, for instance, the European Union is regulating quite heavily under its EU Green Deal on a whole number of different climate and environmental matters. And two important pieces corporations to report on their climate and environmental impacts, to disclose transition plans, and to exercise due diligence across their supply chains. And I could see a situation where you might have a regulatory finding, a fine, say, against a company that sort of fails to comply with those regulations when we see them coming into place, and where that where those sorts of findings have a financial impact on the company. That's where there might be derivative claims, perhaps, or in some shape or form around these regulations that might be a prompt for more of these derivative lawsuits. But I think one thing to say about those is that they're very difficult claims to bring, not just legally, but practically. They're very expensive, they're very risky. And I think, unfortunately, in this litigation context, you always have these sort of David and Goliath issues where you're trying to litigate against very wealthy corporates. And often the claimants are small NGOs or individuals or sort of activists. And so I think there are practical obstacles to some of these claims as well as sort of legal obstacles.
Thank you very much. I'm conscious of everyone's time. I want to thank everyone for joining and including everyone for adding their comments and questions into the chat. We'll try and follow up with some of these via email as well. And to that end, if you're interested in more, please be sure to visit the link in the chat. to sign up for recording of this chat, as well as for some follow-up context and responses from our colleagues. I'd like to thank the IUCN World Commission on Environmental Law, Biodiversity Law Specialist Group for their support today, and in particular to our three speakers. It's an incredible privilege to get to hear from you, and all the more to get to hear from you all together in discussion. As Joana said at the beginning, these are not necessarily new issues, but it really feels like these issues are increasingly coming to a head. There's certainly types of integration of litigation that we're going to be seeing into the future, and it's very clear that this presents lots of challenges, but also lots of exciting opportunities as, let's say, the legal realities increasingly start to reflect the scientific and the lived realities of the relationships between biodiversity, broader nature, and climate change. So thank you very much. And I look forward to seeing all of you again. And thanks so much to your speakers. Have a good day ahead, good evening ahead, and take care. Thank you.
Thank you.
Thank you.
Bye, everyone.
Bye-bye.